All right, everybody. Well, it's great to be here with you. Thank you very much for joining us today. We're dealing with a subject that's somewhat warm, and hence the reason for so much interest in this presentation. It is being recorded, so feel free, of course, to share it with your colleagues and others as we go. And we invite questions as we go. You can put them in the chat, and we'll respond while we dive into this presentation with you. So let's start by giving you a little bit of the lay of the land about what's been going on. In recent weeks, we've been in conversations with high-level folks at Homeland Security, and you'll hear us talking about that crowd today. There are really two sub-agencies that are involved. There's Homeland Security Investigations, HSI, and those are the folks who do worksite enforcement. And they're always working hand in hand with our friends at Immigration and Customs Enforcement, or ICE, and so we'll be talking about them as we go along the way too. So you'll hear us talk about HSI, ICE. The two really can be treated interchangeably, and so we will try to give you some intel into how things are going and dive through with all of this from there. I think we're on the wrong slide, however, so if we could go back one slide, Rachel, that'd be great, and then we'll start to walk everybody through where we're going today. Just by way of background, you should be aware that the entire climate, you already knew this, we assume, but the entire climate in the world of enforcement has changed dramatically. And that started with a memorandum that came out by the Department of Justice that started to lay the groundwork in terms of where things are really going to go with this administration. That memo came out by the Attorney General on February the 5th. And in that memo, she addresses two primary issues for all federal prosecutors nationwide. Number one is the question as to whether charges should be brought. And number two, what charges should be brought. With regard to whether, the answer appears to be generally yes. Criminal charges should be brought. Whenever anybody is referring a case to the U.S. Attorney's Office for federal prosecution, the thought is that they should accept those cases for prosecution. And in fact, if they choose to decline such cases, they need to have a good explanation as to why they're declining those prosecutions, and even report on those decisions not to proceed with charging. So you can see that there's going to be a lot of pressure on local U.S. attorneys' offices to bring federal charges whenever possible. Now, this is all going to sound terrifying at first, but what we hope is that knowledge is power. And so give us a chance as we walk you through all of this, and we'll try to make things a bit less terrifying as we go. The second question, however, is what charges should be brought? And in response to that, the Attorney General says, well, the most serious and readily provable offenses are the ones that should be brought. So we're looking at a whole new landscape now. Those charges can range from new developments, such as the fact that people who are in the country in temporary types of statuses need to carry evidence that they're here legally in the United States at all times. Other situations where people who are here unlawfully need to register and carry proof of registration with them in the United States. So those are going to be areas of concern. But today we're talking to employers, and we're going to be talking to you and what you need to be doing to make sure that you're ready for the three types of visits that generally come. And so let's just give you a brief outline about where we're going today. The first one relates to the knock and talk. As one federal judge called it in Southern California, should really be called knock and arrest. So it gives you some feel as to how federal judges see these knock and talk type scenarios. And in these situations, what will happen is that HSI or ICE will drop by. Usually they're very smiley, and they start asking questions either about a specific employee or about your workforce. And so Samantha will spend some time on the knock and talk. Next is the scenario where they want to serve us with a notice of inspection. That is what initiates the I-9 audit. That's when they want to see your paperwork, your payroll records, etc. And we'll be talking about that as we go here today too, what to expect when you get a notice of inspection. By the way, they're expected to increase dramatically. They're engaged in contractual efforts right now so that they can expand their capacity by 10 times, maybe eventually even more than that, to conduct numerous and extensive audits on an ongoing basis all the time. And then finally, we'll talk about the dreaded raid, the worksite enforcement action. And sometimes people say, well, how do you know when it's a raid? Believe me, you'll know. As I think about the raids that we've handled in the past, I think about one in particular where we had a raid where it was a 100 employee facility, and they ended up sending in 95 agents to raid this facility and had a Black Hawk helicopter hovering overhead. The idea is the shock and awe, right? To terrorize other employers in the industry, to get others to start thinking about what they're doing to ensure that they have a legal workforce. So we'll talk about how you navigate each of these situations: the knock and talk, notice of inspection, and the raid.
Okay, now let's talk about a situation that can happen at any time without warning. This is what's called a knock and talk, or a knock and arrest, as Chris so aptly named it. It might seem informal, but it's often the first step in a larger enforcement effort. How you respond in those moments can have a huge impact on what happens next. When ICE agents show up at your workplace unannounced, they are typically there for one of two reasons. They're either targeting an individual, so ICE may be looking for a specific person, someone they suspect has a criminal history, an outstanding immigration violation, or someone who's just under investigation. Or they're there to target your business specifically. They may be conducting an informal investigation into hiring practices, workforce compliance, or possible immigration violations. What this essentially means is that they are gathering information. At the time that they arrive with the knock and talk, they may not yet have enough evidence for a warrant. So when ICE shows up, your best response is to follow the 3 C's. Be courteous, stay professional and polite. Do not escalate the situation. Be closed mouth, which, if you're like me, is a bit of a bit of a high ask. I love to yap, so it's important to remember in these situations to be closed mouth. You don't have to be polite and make small talk. Do not answer any question. You should be polite. Backtrack a little bit. Yes, be polite, but do not make too much small talk. Don't answer any questions. Do not provide details about employees or hiring practices, and do not speculate or make assumptions about why they are there. And get counsel. The last C is most important. Maybe Chris and I are a little biased, but we do think that it's the most important. So immediately call the company's attorney to handle all communications. Your goal in these moments is simple. Stay calm, say nothing, and get legal involved. One of the biggest mistakes that people can make during a knock and talk is assuming that they know what or who ICE is looking for. The reality is you don't. So consider these key questions. Who is the target of the inquiry? What are the agent's goals? And are they asking about one specific person or the entire employee population? You won't have the answers to these questions in the moment, so the best response is to let legal counsel handle all communications. When an ICE agent approaches you, it can be a scary situation. You may be nervous, but the best response is simple and firm. We really want to help you. Unfortunately, I'm not authorized to answer any of your questions. Let me get our company attorney on the phone. This response is polite, but does not give them any information. It also signals that you are not resisting cooperation. You are just ensuring that the right person handles the conversation. Remember, ICE agents are here on a fact-finding mission. They don't have a warrant yet, which means they don't have enough evidence at this time to conduct an enforcement action. Their goal could be to gather information that may lead to an I-9 audit or a worksite raid down the road. If they start asking about hiring practices, they may be trying to establish patterns of non-compliance. That's why it's critical to not answer any questions and to immediately refer them to legal counsel. You may, I had one more bit to add there. So you may ask yourself, what should I do if ICE asks about hiring practices? Remember, you can say, I'm not authorized to discuss hiring practices, but I'd be happy to connect you with our legal counsel. Don't elaborate. Even if the question seems harmless, ICE may be looking for patterns of non-compliance, so just defer that question to legal counsel. Another question you may ask yourself is, can I tell ICE that an employee they're looking for is not present if I'm unsure? No. If you say someone isn't there when they are, that could be considered obstruction of justice or harboring. Instead, just respond with, I'm not sure, but I can put you in touch with our legal counsel. The key takeaway here is simple. Be courteous, be closed mouth, and call counsel. These moments matter, and the way you handle a knock and talk can determine what happens next. Now let's move on to what happens when ICE takes the next step, and they issue a notice of inspection, which requires a business to turn over I-9s and other records for an audit. So this is an example of a notice of inspection. When a notice of inspection is issued, it means ICE is formally demanding access to your company's I-9 records. This is no longer an informal inquiry. This is a legal requirement that must be handled properly. Once a notice of inspection is served, you have 3 business days to provide your I-9 records and supporting documentation. It's important to remember that we can negotiate a longer turnaround. So that's why we ask that you reach out to legal counsel right away so that we may be able to negotiate an extension. When responding to a notice of inspection, we're going to keep coming back to this. Remember your 3 C's because they apply in almost all of these scenarios. So courteous, accept service professionally, take the notice of inspection without argument or unnecessary conversation, remain closed mouth, do not answer questions. ICE agents may try to use this opportunity to ask for more details. Don't fall for it. Do not engage in small talk or answer any questions about employees, hiring practices, or document retention. And then contact counsel immediately. Get your attorneys involved as soon as possible because we may be able to negotiate more time and review records for compliance risks before submitting them. So let's just go over that one more time. What should you do at the time of service of a notice of inspection? Ask for the notice of inspection or subpoena professionally. Ask for the ICE agent's business card. Do not hand over any documents on the spot, and notify legal counsel immediately so they can guide on the next steps. It's important to remember that a notice of inspection is not an emergency, but it is urgent. The way we respond to this notice of inspection in those first few minutes can determine how smoothly the process goes overall. Speaking of the I-9 process, it follows a 3-stage path. When there's an I-9 audit, it will follow a 3-stage path. The first stage will be the service of the notices of inspection and your response. This is where ICE will request the I-9 forms and the documentation, and you provide them timely. The next stage is the notice of suspect documents. And this is a big maybe. And the reason why it's a maybe is sometimes we see ICE skip this step. So they may issue a notice identifying employees whose work authorization appears questionable, but we are seeing an increasing trend where ICE skips this step entirely and just moves straight to the penalties. Which brings me to the final outcome, which is one of three possibilities. Either you're issued a notice of compliance, everything is in order, no further action. You're issued a warning notice. ICE finds an issue but does not impose fines, or you receive a notice of intent to fine. This is where ICE moves to penalize the company for violations. The challenge here is that we don't always get a warning. ICE may move straight from requesting documents to issuing fines, which is why having legal counsel review everything before submission is so important. So why should we care about an I-9 audit? Because it can actually have very serious consequences, including civil fines that can range from thousands to sometimes millions of dollars, which we can help negotiate those down. There can also be criminal liability. If ICE finds willful violations, criminal charges may follow. It can also have a serious operational impact. If key employees are flagged for work authorization issues, business operations can be severely disrupted. And that is why it's always critical to proactively review I-9s before ICE gets involved. If legal counsel is brought in early enough, we can help identify potential issues before documents are submitted, giving the company more time to develop a strategic response. The key takeaway here is this. A notice of inspection is serious, but it is manageable if we respond correctly. Accept service, stay silent, and immediately involve legal counsel. The goal is to handle this proactively, not reactively, because the right response in early stages can make all of the difference in avoiding heavy penalties. Next, let's move on to what happens when ICE takes enforcement to the next level with a full-scale worksite raid. So as Chris alluded to in the beginning, these can be very intense situations. So an ICE raid is high intensity, high pressure. It's fast moving, and it can feel very overwhelming and scary. You may see armed agents, badges, and Chris has even seen helicopters. So very, very intense. But the most important thing to remember in this moment is stay calm. Your job is to be the calm in the storm. From the moment ICE enters your workplace, you need to follow a clear, disciplined process. Step one is going to be determining if they have a warrant. You'll ask if they have a warrant. If they don't have one, they cannot go beyond public areas. If they do have a warrant, determine what type of warrant it is. Is it a judicial warrant signed by a judge and valid for search and seizure? Or is it an administrative warrant issued by the Department of Homeland Security and not valid for search and seizure? If they don't have a warrant, they have no right to go beyond non-public areas. If they do, then we must monitor them carefully and ensure we document everything they do. One of the most critical things that you can do during a raid is record and document everything. If ICE tells you to stop recording, they don't want you to use, your camera phone, they tell you to put your phone down, pick up a pen and paper, start taking detailed notes. And when you're taking those notes, these are the things as your legal counsel we want you to document. How many agents are present? What are they taking? Are they treating employees fairly? Are they making any verbal statements about the company or employees? At the end of the raid, ICE should provide an inventory receipt where they will list out everything that they have seized. Do not take that at face value. Compare it to your own notes. Your documentations could be critical for a legal defense. During a raid, ICE agents typically divide into 3 groups, each with a specific role. There are agents focusing on perimeter security. They will secure all exits. No one should try to leave through the back door, for example. Employees attempting to flee could face serious legal consequences. There will also be ICE agents focusing on search and seizure. ICE will confiscate physical and digital evidence, including computers, files, and employment records. Your job is to shadow them and write down everything they take. The final group of ICE agents will focus on employee questioning and detentions. Employees are not required to answer ICE's questions. They have the right to remain silent and request an attorney. At the end of the raid, ICE will hand over the inventory receipt listing all of the items that they have seized. This is where, as I mentioned, your own documentation will become critical. Compare that receipt to your notes. Did they take more than they listed? Are there any discrepancies? Were items removed that weren't within the scope of the warrant? Any inconsistencies should be flagged and reported to legal counsel. ICE raids can be overwhelming, but by following these steps, staying calm, identifying the warrant type, documenting everything, and ensuring employees know their rights, we can minimize the legal and operational impact. The key is preparation. The more you understand these processes now, the better positioned you'll be if this ever happens. Chris, did you have anything that you wanted to add about Worksite raids?
So as we dive into it, I think we'll talk a little bit more about the do's and don'ts, how not to get in trouble, et cetera. And I think Samantha will be talking to you about judicial warrants versus administrative warrants, so you know the difference. I think what I would tell you is that these, as Samantha alluded to, these are highly charged events, right? You got suddenly SUVs rolling in, the helicopter overhead, you've got buses coming in, sometimes military vehicles. It is a major event. And to her point, this is your chance to be the one person who keeps it cool. We need you to be the calm in the storm. It's the same speech we give our attorneys here. When things blow up, we're the calm. And that's what you'll need to be. Somebody's got to diffuse the situation. Hello, agent, how can I help you? And start to go through these steps. And then just to hammer home the point a little further, I have seen this 1,000 times. It's as if somebody's priest or bishop or rabbi or whatever religious persuasion you are, as they walk in, suddenly people start confessing. You know, they can say, my goodness, the only reason we're employing all these undocumented people is that we can't find legal people in this country. Well, you just admitted to a lot of felonies with that sentence. So slow down and let us do the talking for you. We deal with federal agents for a living. We've done it for years and years. I'm 28 years into this. We know what the traps are, what they're trying to get at. And in my conversation or Samantha's, when they start asking questions, we'll probably be saying something along the lines of, look, you know I'm not going to answer that question. and they'll laugh and we can laugh it off together. But if you're having the conversation, it'll be a much more intense type scenario where you feel pressured, like, okay, I better be responding. Just slow down and say, let us get our attorney on the line. And your attorney can have the conversation with them so that things go the way you need them to go. Don't make the situation worse than it already is. It's already a big deal. Let's not spiral off the rails here and get really into trouble.
Okay, well, next we'll dive into different types of warrants. So judicial versus administrative, so you can know exactly what to look for in these type of situations. So here's a template of a judicial search warrant. The judicial search warrant is the only type of warrant that allows ICE to search restricted areas and seize property. It's very important to recognize what a valid judicial warrant looks like, and just as importantly, how to spot a problem with one. If ICE presents a warrant, your first step is to verify its authenticity, preferably with the help from legal counsel. Mistakes happen, and if the warrant is flawed, ICE may not have the authority to proceed. So how do you know if a warrant is legitimate? There's 5 key checks that need to be performed. The first one is check the issuing authority. A valid judicial warrant is issued by a U.S. District Court. If the warrant was issued by the Department of Homeland Security, it is not valid for search and seizure. That's an administrative warrant, which does not grant ICE broad entry. You also want to confirm the warrant has the correct address. ICE has rated wrong locations before. In fact, we've had, what is it, Chris, at least 2 clients that this has happened to. So double check that the business address on the warrant matches your location. Ensure the warrant is still valid. Some warrants will have strict time frames. They also may have date and time restrictions. So they may not be authorized to do a midnight raid, and then they do a midnight raid, and that does happen. So it's really important to verify when they're able to come in. And review exactly what ICE is authorized to take. So not all judicial warrants are the same. Some only allow for the collection of digital records, while others authorize the seizure of physical files, computers, and other company property. So that's where you're going to want to follow the ICE agent and take notes on what they seize, compare their actions to the warrant's scope. Finally, ensure the warrant is signed by a federal judge. A valid judicial warrant must have the signature of a federal judge. If it's missing the judge's signature, ICE does not have search and seizure authority. If something seems off, whether it's the wrong address, an expired warrant, or ICE seizing items that are not listed, you should make sure that you're documenting everything, keeping detailed notes of the issue. Do not confront the ICE agents directly. Instead, let legal counsel handle it. And always stay professional, stay calm. Even if ICE has a judicial warrant, it does not give them unlimited power. They must follow the warrant's specific terms, and our job as legal counsel is to make sure that they do. So here are some potential questions. What if the warrant is issued by Department of Homeland Security instead of the U.S. District Court? That is an administrative warrant, not a judicial warrant. Administrative warrants do not authorize search and seizure. Also, ICE cannot enter non-public areas or take company property. What should you do if the address on the warrant is incorrect? Notify legal counsel immediately. If the warrant is for a different location, ICE may not have the authority to conduct a search. Can ICE execute a raid at night or early morning? Yes. Some warrants allow enforcement at any time of day, including overnight raids. This is why it's important to have a clear response plan in place before an incident occurs. Okay, so far we've talked a lot about judicial warrants, which give ICE significant enforcement power, but what about administrative warrants? These are much more limited, yet ICE often uses them. Let's break down what an administrative warrant is and what it does and does not allow ICE to do. First, an administrative warrant is not the same as a judicial warrant. It is issued by the Department of Homeland Security, not a federal court. And it does not give ICE the broad search and seizure powers of a judicial warrant. If ICE presents a judicial warrant, it's important to know what it does not authorize. ICE cannot enter non-public areas. This is why we also recommend clearly labeling restricted areas as employees only or restricted access to establish these boundaries very clearly. ICE cannot conduct a search or seizure on company records, computers, or files. This is a very common misconception. An administrative warrant is not a search warrant. You are also not required to introduce ICE to an employee. ICE may ask to speak with a specific individual. In this situation, the best response is, "I'm not able to discuss this with you. Please let me get our attorney on the phone." Even though ICE's powers are limited under an administrative warrant, this situation still needs to be handled very carefully. Here's what to do, going back to the basics: remain courteous, closed mouth, and call counsel. Remember to be polite, but do not provide voluntary information. Of course, be honest, don't speculate. Giving incorrect information, even accidentally, could lead to legal consequences. Mark and enforce non-public areas. Have clear signage that distinguishes public from private spaces. And be aware of possible follow-up actions. After an administrative warrant visit, ICE may return with a notice of inspection to conduct a broader investigation into the company's hiring practices. This is why documentation is key. Track every interaction with ICE so legal counsel can prepare for any follow-up. And finally, understand your Fourth Amendment protections. The Fourth Amendment protects businesses from warrantless searches and seizures. ICE cannot enter non-public areas without a judicial warrant or your permission. It is best to always refer them to legal counsel if they ask for permission. Okay, so the key takeaway here is that an administrative warrant is not a search warrant. ICE has limited power, and the best response is to stay professional, enforce non-public area restrictions, and refer ICE to legal counsel. Next, Chris is going to cover a critical part of handling an ICE raid: documentation.
All right. Well, thank you very much, Samantha. And I guess I'll just add, as we're talking about warrants, remember that it's the judicial warrant that allows you to search, or allows them to search and seize, to go into non-public areas. Or you could allow that to occur simply by consenting. Please don't consent. That's not what we're looking for here, right? If they come in, they say, "We want to see this place," we know that's intimidating. And so get legal counsel on the line who can say, "Look, guys, if you're going to come in and conduct a raid here, you got to have the right judicial warrant for you to be able to carry that out." Now, there are some things that we need you to be recording while a raid is going on. So let's talk through some of those. And as I told you, the best, or as Samantha told you, the best, of course, is for you to record what they're doing, play by play. As we alluded to, there are really three jobs. There's the group that secured the perimeter. There's the group that's searching and seizing documentation, computers, etc. And then there's the group that's questioning employees. We, of course, are interested in the activities of all three, so you may have to divide and conquer, right? There might be three of you at each facility who kind of goes around and follows or records what they're seeing, so that later on we have a way of discussing with a judge or whoever we need to discuss this with, what we saw, how things played out. Now, as Samantha also mentioned, sometimes they're a little bit threatening. We've seen situations where agents have turned on somebody who's recording their activities and will say, put your phone away right now, or we're gonna arrest you too. All right, we don't want you to get arrested, right? So in that situation, you just say, that's fine, put your phone down, but that doesn't mean you walk away and leave them to do whatever it is they're about to carry out. You're following along with a pad of paper and you're taking notes. We've seen inventory receipt situations where they say, we took 6 computers and it turned out that they actually took 9, etc. So we do need to know. We also need you to be in a situation where you're advocating. Some of you run manufacturing facilities where, if they take some of the computers, it shuts down the machinery. Well, good heavens, we don't want that to happen, right? That puts you out of business. So let them know, hey, your warrant says that you're entitled to computers with employee files. These computers here, they don't have employee files. All they do is have the purpose of keeping this machinery going. So again, just be present. If you're intimidated by it or you're not in a position where you can talk about it, hand the phone to the agent. Let us have the conversation with them or whoever your legal counsel is. Now, in particular, we're going to be interested in the following things. How many ICE agents were present, inside and out? Did you get their names, badge numbers, business cards? We know you're not going to be able to get all of them if they send in 95 agents, but we're definitely interested in the lead agents. We want to know who those people are, who we need to be talking to. How were they dressed? Were they in plain clothes? Were they wearing the usual black vest that says police on the back and then it says either HSI or ICE? Or were they in military gear? Sometimes you'll see that too. Were they armed? If so, how? Weapons drawn? Hope not. But we want to know exactly what it is that you are seeing. Did you ask if you or your employees were free to go? This is a very important question in the world of law, because if somebody tells me that I'm not free to go, what it means is that I'm in custody. I'm deemed to be under arrest. And so we want to know. So one of you at the company should probably say, hey, there's something I need to take care of. Am I free to go? And if they say no, well, we want to know about that. That's obviously a very relevant tidbit for us. Did the agents threaten or mistreat anyone? A lot of what we're hearing across the country right now is that some of that's going on, as raids occur, there's a lot of threats. Give me this or you're going to face that kind of a thing. We want to know about that. For example, if they're coming in and they don't have warrants and you say, I'm sorry, I can't let you go into non-public areas, and they threaten you, we want to hear about it. Absolutely critical for us to know about that kind of situation. Did the agents arrest anybody? If so, who? Where did they take them? This is for the humanitarian side of all of this, right? If we do have people that have somehow slipped into our workforce, people who gave us bad documents that looked good on their face, maybe they were even good enough documents that they passed E-Verify because they had assumed somebody else's identity. For all intents and purposes, you know they're here legally. But suppose that they do find that some of those people did mislead us with bad documentation. Well, if that's the case, we want to know who those people are and where they were taken, because you're going to have a pretty uncomfortable conversation that you're going to have with each family, right? There's the humanitarian side. I am sorry, but your spouse was arrested today and was taken to X facility. Again, that's when they're probably going to have to mobilize. They need to get their own deportation defense attorneys, all of that. But we want you to be in a position where you're ready to give people as much information as possible. Agents won't always tell you where they're taking people, but it's always worth asking the question. Moving on to the next slide. As we talk about this, we also want to make sure that you're not getting in trouble. Please don't make a bad situation worse. As I told you earlier, it's critical here, right? So do not interfere with agents. Well, how can you interfere? One way is to alert employees that ICE is on the scene or help them leave. We just saw a raid in Louisiana a little while ago. And in this raid, believe it or not, the plant manager ends up sending texts because he was worried that the morning shift was about to begin. And so he sent texts out to all Spanish-speaking employees, not all employees, just all Spanish-speaking, saying, hey, ICE is on the scene. Make sure you don't come today. Well, as you can imagine, it's not going to go well for that plant manager. In another situation that we handled a few years back, there was a situation where a raid was going on at a plant, and one of the supervisors tried to open the back door and allow people to go out the back. Well, again, the perimeter's already been surrounded, right? We've got agents on the scene, nobody's going anywhere. And the problem we have at this point is now that supervisor is going to be charged with obstruction of justice and harboring. And in fact, he was. So again, let's just think about this stuff. Let's think about what we do and don't do. We want you to be heroes. This is not the time to try to be a hero. Not the time to try to step in, interfere, in any way obstruct the efforts of these agents. Don't litigate the case with ICE agents. Oh my goodness, we have seen so many people try to do that. They just say, do you understand what we're dealing with here? We are trying to keep this business going and you can't find legal workers to keep it going. Well, you just made some big admissions, which, as I'll explain later, could end up sending you to prison for a very long time. So just don't do the talking. Let us or whoever you use as your outside counsel support you in this type of situation. Don't answer questions about company hiring practices, employee population, people suspected of being unlawfully present. They're going to try to hit you with those, and we're just going to say, hey, I think I told you earlier that I'm not in a position where I can answer those questions. Let me introduce you to somebody who can, and then we'll have that conversation, okay? Never lie. Mom was right. It's never a good idea to lie. It's especially a bad idea to lie when we're talking about federal agents. That's a criminal charge in its own right. So the example Samantha gave is ideal, right? If they're looking for John Smith and you say, well, John Smith isn't here, and he is, well, you lied to a federal agent, you obstructed their efforts, and you harbored. That's all serious stuff. All three are felonies. We're now getting ourselves into serious trouble. So instead, you just say, I can't answer that question, but I have somebody here on the line who can, and then we'll have the conversation. Don't destroy evidence. I know you're listening to me saying, who would be that dumb? Well, we've seen it. Right? We've seen situations where people immediately start deleting texts or they're trying to hide papers that may be incriminating in some way. Don't go down that road, right? Let's keep it smart. Let's let the process play out. Don't you interfere. Once they're on the scene, you're setting yourselves up for a catastrophe if you do. Then moving on to the next here. This is the hard piece, and Samantha alluded to this a little bit. I'd like to spend a moment on it. Everybody in the United States has a Fourth, Fifth, and Sixth Amendment right. That means that you have a right under the Fourth Amendment not to be subjected to an unreasonable search or seizure. Under the Fifth Amendment, you have a right to remain silent. And under the Sixth Amendment, you have a right to counsel. You do, and people who are unlawfully present do. Everybody has these rights. So as we look at that and we think, so what do I do to educate my employees? Well, it can be complex, and you may have even heard Tom Homan and others threaten people who talked about how they were going to educate people about their legal rights. Now, I don't think the courts are going to agree with Mr. Homan that you can't educate people about their legal rights, but I do worry about the optics, and I want you to think about that just a little bit. The risk is that if you're bringing in people to educate your workforce about their legal rights, it kind of goes to mental state, doesn't it? Could it not be construed as a scenario where you knew, or you were consciously aware or deliberately ignorant, willfully blindness, whatever terminology you want to use, that you might have a problem with undocumented workers? If so, I think that that can be problematic, and we want you to think about the optics. Possible obstruction, again, impossible to imagine, but the world of possibility is changing lately. We're seeing a new approach where we just can't tell you for sure whether it could be construed as obstruction. Tom Homan says it would be. He's the immigration czar, if you're not acquainted with who that is. So play with it. We think probably not a best practice. The better practice is probably to invite somebody like the ACLU, local church group, local community organization of some kind to put on some kind of a Know Your Rights event and then invite people to it. And you don't have to invite them, let them do the inviting. We're seeing these communities throughout the country, and it's not a bad approach, of course. Now, we do understand the benefits, of course, of educating employees about their rights. Protects employees, right? We love these people. These are the people we work with. They help us. We understand that interest, and it demonstrates solidarity, compassion, that we want them to be protected. A lot of people worried that they're going to be picked up in a raid even if they're here legally, right? Somebody with temporary protected status, somebody on a temporary work visa, somebody who's a permanent resident, or other types of people, if they don't have their documentation with them, might just be deemed to be here unlawfully if they seem foreign, and that could be a problem. So we want people to know their rights, but as we said, encourage outside organizations to train your community, the entire community, before enforcement actions occur. And here's what we don't want you to do. When a raid occurs, as we told you, there are kind of the three roles. Secure the perimeter of the agent, those agents that do that, those who engage in the search and seizure, as outlined in the warrant, and those who question employees. We have seen scenarios where they will say something along the lines of, okay, for those of you who are here unlawfully, line up on the right. For those of you who do have good documentation, you're on the left. Well, the temptation, of course, would be in that situation for you to interfere and say, okay, you don't have to do that. You don't have to do anything they're asking you to do. All of you have a right to remain silent. That's going to put you in the crosshairs. In the heated situation of a raid and so on, they're going to turn on you and say, I think you're obstructing with our investigation right now, with our raid, and take you into custody too. So it's too late at that point. If you're going to do something to educate people about their legal rights, let's do it in a methodical way. Let's do it with some outside community organization, civil rights group, etc., helping us get this done. And then as we go to the next slide, we want to talk with you just a little bit about the criminal toolbox. We've heard about some of the crimes with which we can get charged. And I share this with you because we want you to know what could really get you into trouble. First of all, if you lie, if you try to hide people, you're going to get in trouble. We recognize that, of course, and hopefully that's come through. But I'm thinking more now about the immigration-related charges that can come. You can see here that there are a lot of different charges in this toolbox that they could use. Remember that they're supposed to bring the most serious, readily approvable charges. It means they're not going to bring the pattern or practice charge. That's a misdemeanor. It's only punishable by 6 months in jail. Probably not going to bring the next one, knowingly hiring 10 or more unauthorized workers in a 12-month period. It's a felony. It's punishable by 5 years. But the favorite are the next two. Favorites are the next two. Harboring or shielding undocumented workers from detection. If you know or recklessly disregard the fact that somebody's in the country in violation of law and you shield them from detection, you harbor them, etc., then you're getting into a realm where we're looking at very serious criminal exposure, both for you individually and for the company. If it's for financial advantage, it's up to 10 years per count. So that's a lot. And If it's in a situation where senior management in the company knew about it and took no action to address the issue, then the entity itself can be prosecuted and face disgorgement of profits, forfeiture of assets. This is the kind of stuff that can end the world for a company. One company who is facing these kinds of charges recently settled for $95 million. So we're talking big money at this point. The favorite of them all is the next statute. That's encouraging or inducing undocumented workers to remain in the country in violation of law. So if you know somebody's here unlawfully, or you've had a lot of warning signs, mismatch letters from Social Security, Internal Revenue Service, or you've even had situations where people have talked to you, well, that's the kind of situation where it can begin to put you in a serious danger zone. Again, punishable by up to 10 years per count, and it can be the situation that leads to something much more extreme than that. I see we have a question here. It says, what we should say if we get a call from an employee who has been contacted by ICE. Very good question. Thank you for raising that question. Let me preach for a moment a philosophy of paranoia, and we want you to pay attention to it. One of the favorite tools in the current realm right now is to flip long-term employees against us. It's just something that we've seen under Trump 1.0, and we saw it a little bit during the Biden era, and we're seeing it again. And what can happen is that somebody can come in and say, hey, I've been contacted by ICE. I'm in a little bit of a pickle. They're talking about charging me and trying to deport me. Wondered if you guys can help me. Well, I want you to assume that a conversation like that is being recorded, because it very well could be. And so you're creating Exhibit A, either Exhibit A for the prosecution to take you down, or for the defense. If you're creating one for the defense, it would go something like this. I'm sorry, I didn't know that you had a problem with your immigration status. We can't help you with what's developing here, and we're going to have to terminate your employment if that's what your status is in the country. You just have to do it in the current environment. There's no flexibility in this type of situation. So if we get a call from an employee who has been contacted by ICE, first, it's that. Second, it's time to part ways with that employee. Third, if you love this employee to pieces and you want to help, it's perfectly acceptable, of course, to reach out to some outside deportation defense firm that could support that individual as he or she goes through potential removal from the United States. Remember that we never lie on the I-9. Never. I-9s are signed under penalty of perjury and visa fraud, 2 felony statutes. It's not okay to say that you met with the employee, that the documentation reasonably appeared to relate to that employee and to be genuine, and that to the best of your knowledge, that employee is eligible to work legally in the United States, if you know that's not true, right? So you're not required to be document experts. It's a reasonableness standard, but let's keep it cool. I'm not even going to go into the forced labor, benefiting from forced labor piece. That is the ugliest of the world of ugly in the world of immigration. But it does happen. We have seen situations where it does happen, where undocumented people infiltrate the workforce. And it's usually because it's a cartel type network where they have now arranged for people to be in the country. They're giving them fake documents. People are paying kickbacks in exchange for the kindness of them being smuggled into the United States, etc. Anything like that pops up, really anything on this list, and you need to be talking to knowledgeable immigration counsel about what you need to do to clean it up. You can clean it up. It's not the end of the world, but you don't wait until federal investigators are on the scene. It's the kind of thing that needs to happen now. One more thought. Well, let's go to the next slide and we'll talk about that thought and talk about how you prepare, what it is that we need to be doing to get ready here. And as we do that, let's just talk about some of the key steps. First, your I-9s. Make sure that you are engaging in the internal audit. Make sure that you're cleaning things up. Now, I can tell you time and time again, under Trump 1.0, we had companies that went through I-9 audits. They did not have their documentation in proper order, but they cleaned it up before HSI showed up on the scene. As a result of that, they ended up walking away with a warning notice No fines imposed because they cleaned it up before they showed up. It's way too late to find religion after they show up, right? If you suddenly have this frantic 3-day cleanup once they're on the scene, you're too late. They're not going to be impressed by that at all. But if you clean it up before they get there, you might be okay. Keep in mind that I-9 audits are not just a tool to impose civil fines. It's not some innocuous event. It could mean civil fines, but it's often in the current environment, what we're seeing across the country right now, it's an effort to gather evidence against employers. So again, make sure that you're cleaning things up, but you're cleaning them up right, that you're not engaging in knowing employment of undocumented workers, etc. Next, stop the bleeding, for crying out loud, right? Let's make sure that we have our employees going through appropriate compliance training, establish written I-9 compliance policies and follow them, of course. Enroll in E-Verify. It's time, right? It's time to show that we're showing good faith, that we're using the tools the government has made available to us. We all know that E-Verify is not perfect, that it can be skirted. Homeland Security knows it too. But if you use it and you use it right, it shows good faith and it makes you a whole lot easier to defend. Some people ask, well, what about the image program? That's a program that's offered by Immigration and Customs Enforcement where you can partner with them. There's a hitch, and the hitch is that you need to subject yourself to a full I-9 audit with them. So you need to decide, are my I-9s in good enough order? Are they going to find any potential irregularities, etc.? We usually tell companies to enroll an image when the sky is falling. It's too late. There's nothing else we can do to fix things. So again, it's not probably the best choice for you, but if you have questions about it, you want to talk about it, we can talk about the pros and cons. Reduce exposure. If you know you have undocumented workers, it's time to find a way to start phasing them out. And it's time to have a much more rigorous onboarding process to phase in people who are lawfully present. You just can't take the risk anymore. The I-9 audits are expected to get up to 6,000 I-9 audits per month. The old record was 6,000 in a year. So they are contracting, they are laying all the groundwork right now. And remember that cases are to be referred for criminal prosecution if they find that they have something that shows you're knowingly employing undocumented workers. And once they're referred, Department of Justice shall accept these cases for prosecution. So again, we're just asking you to be careful, clean things up now the best you can. And then if you do know that there are problems, again, reach out to knowledgeable counsel. Time to start cleaning things up now. Circle the wagons now, way before the agents show up on the scene. And then have a plan to respond to mismatch letters and other such things, right? If Social Security sends you mismatch letters saying these Social Security numbers do not match the numbers of the employees you gave, you can't ignore that. People did ignore those in the past. Don't try to do it again now. It's a pretty serious environment. All right, we could go on and on. We know it's horrifying. Hang with us. We're in this storm together. If any of you have questions and you want to talk about it, we're happy to chat with you and talk about some of the do's and don'ts to make sure that you're ready for any kind of on-site visit from our friends at Homeland Security. Thank you, everybody, for your time.